morning. Thank you so much for coming, and I suppose I want to thank you for your loyalty to our annual conference, which we really appreciate. It's very much a fixture in our calendar, and we're delighted to have you here. Also, in terms of loyalty, I'd like to thank our sponsors, Smith & Williamson, who also have been very loyal to us and indeed are sponsoring our talk here today. And there'll be many members of Smith & Williamson floating around throughout the day should you like to talk to any of them. I suppose I'm impressing your loyalty upon you because we have some very exciting news that we really want you to be a part of in the next 12 months, and that's that Dublin will host the STEP International Congress next July over 2 days. So on the 7th and 8th of July 2020, a Tuesday and a Wednesday, this STEP Congress will be hosted in Dublin. It will take place in the Intercontinental Hotel. And we're really very excited about this. I don't know the extent to which you might be familiar with STEP Congress. It takes place every 2 years. It just took place in Vancouver last September. There was over 45 speakers. There was 250 attendees. So it's a really wonderful opportunity to come together and network, I suppose, on a more international basis than perhaps we would be used to doing here. And so as part of that for 2020, we're not going to host an annual conference. We're going to encourage our members to try and attend the Congress if they can. So we want you to start thinking about it now, engaging with it, engaging with us, and the extent to which you might want to become involved, be it coming up with ideas of the kind of talks you think would be good, or speakers, or sponsorship opportunities, and really, I suppose, engage with the idea of Dublin, our branch, Ireland, hosting, or co-hosting, I suppose, this STEP International Congress. Now, it is a very different kind of event, obviously, to our annual conference, and we know that you're all very loyal to our annual conference, which we appreciate. So we will ensure that if you don't choose to attend the Congress, that there will be appropriate CPD opportunities for you. You're more than familiar, I'm sure, with our lunchtime seminars, which are really successful. And so there will certainly be adequate CPD opportunities for you if you choose not to attend. But we really, really want to encourage you to engage with the Congress. It's a fantastic opportunity for Dublin. Kerry Linstead, who's head of events, is here today with STEP. And also Chief Operating Officer Jim Wilkinson. They're both here today to talk to us about it. We'll have a presentation from STEP as well, and they'll go into a little bit of detail on it. You'll see, I suppose, the theme of our conference is a changing world, and I know we're all, I don't want to say we're saturated by Brexit, but unfortunately it's something that we have to look at, we have to address. Never is the theme of our conference so relevant than today in terms of the news that's obviously going to come from the UK probably at some stage today in relation to Theresa May stepping down. So it really is a state of flux. As one of our committee members said, Barry, said, we'll probably have Brexit as a rolling STEP agenda for the next 5 years. It'll probably always be a feature in our annual conference. So we do have a Brexit panel today, but I think how we're approaching Brexit in terms of our panel, we have a speaker from Spain. We have the chair of Spanish STEP, and so he'll give us a look at the sort of a civil law jurisdiction. We'll also then focus obviously on Ireland, and we have a speaker as well from the UK. So we'll have that sort of tripartite look at 3 different jurisdictions, but really not only will it look at Brexit, but it will focus on that sort of civil common law jurisdictional differences. Because I suppose as a committee, given that the UK are leaving, we have very much focused now on STEP Europe, and we've become much more involved in STEP Europe as an entity, and we're delighted to have Alberto from STEP Europe, and as I said, the chair of STEP in Spain with us as well. So we're also very lucky today to have Ms. Justice Marie Baker from the Court of Appeal to open our conference. As many of you will be aware, Ms. Justice Baker was the probate judge for many years, and she's been on the Court of Appeal for the past 12 months. So I'll invite Judge Baker to open our conference now first. Thank you.
Thank you very much, and you're all very welcome. And the legal landscape continues to change. I think this is the 4th year I've opened this conference, and the 4th year I've had the opportunity to be engaged with reading the materials, which is very good. The topics are always difficult, but one of the nice things about this conference, I always feel, is that it's very educational. I want to talk to you very briefly. There's a number of very important I suppose, developments in the law in the year, but they've been dealt with by the papers. I want to talk to you about something that perhaps some of you have missed, which I think is important, which is the new judgment of the Court of Appeal in a Section 117 claim. I think it's important for a number of reasons. I was a member of the court, so I won't be commenting on it, but I will be telling you what it says, and I will be telling you what to look out for. The reason I talk about it is partly because it's actually very difficult to know what to say when you open a conference. I mean, I could just say have a good day, but that's probably not quite what my function is. This is an important judgment for the obvious reason that it's the first judgment for a long time of the superior courts. It's a Court of Appeal judgment. It's a Court of Appeal judgment from 3 judges who worked in the commercial and chancery side. So it comes from 3 judges with a lot of knowledge in the area, and I think it will have some force as a result of that. But it's an important case because 117 is an area that almost anyone in practice will come to deal with, probably several times a year. And 117 is also an area of law that I think a lot of clients are very interested to know about, and the man in the street is very interested to know about. And there's come to be, probably at some level, some disconnect between what people expect a 117 result to be and what has been the result. And there's also been something, and I know when I was the probate judge, I was quite conscious of this, even though the probate judge doesn't do 117s. And it was the sense that there had developed a habit of commencing Section 117 proceedings because you would always get your costs, and because there was no risk, and because you'd probably squeeze something out of the estate because the cost of running the case was always prohibited. Now, the only disappointing thing about the case that we decided only 2 months ago was, and it was disappointing only to an extent, is that the parties more or less conceded the costs. And we adjourned the hearing of the costs application after we delivered our judgment, when we completely reversed the finding of the High Court judge and we rejected the 117 claim in very unequivocal terms. We didn't get to decide the question of costs, so I won't tell you what our thinking might have been had we done it, but it is then I think probably the next frontier. And in the light of the now well-established jurisprudence from Elliott and Stamp, it seems to me that we have to have a very serious look at the cost orders in unmeritorious or unsuccessful 117 claims. 117 is not uniquely Irish, but it is probably in its tone fairly uniquely Irish. And it had a very important, and still has a very important, social function, but it's hard sometimes to explain to people how adult children of considerable age can find themselves in a 117 situation in the circuit of the High Court. One aspect of this that did in fact occur to us in the course of the hearing, it was part of the exchange with counsel, was why they didn't bring it in the circuit court, because the circuit court has unlimited jurisdiction in probate matters. The estate was worth 1 point whatever million. The reason I say 1 point whatever million is that the figures were so different from the time of death, the time of the hearing in the High Court, and the time of the hearing in the Court of Appeal, that it was extremely difficult to even start talking about figures, but I will in a moment. In any event, this is a case called WB, and it is actually called WB v JB, but in fact it's easy to find because it's probably the only decision, I think there's only 2 decisions this year in the Court of Appeal which have initials. And it's still the practice that we use initials in these cases, and that is a practice that derives from the Act, and it's not going to change. But these brothers were in their 70s when the case came to be heard. They were in their 50s when their mother died. They were all working, as it were. There was nobody with any physical disability or mental disability. And it was a very tricky case because it was almost an illustration of Irish history in a number of ways. The plaintiff was one, there were 5 children. As it turned out, 2 of the children sued, 1 abandoned his claim. So there was only effectively the brother who sued and the brother who was the executor. He took a long time to take out a grant. There was an argument in the course of the High Court and not much of an argument in the Court of Appeal regarding whether that delay was prejudicial. It was certainly prejudicial on the facts in that the claim was against the estate of the mother, and the mother died in April 2001, and it took 10 years to take out the grant. And in that time, property prices increased and then fell. So it was a particular profile regarding the property market, which came for some consideration in the High Court. But in fact, that really isn't the legal point in the case. The legal point in this case is, I think, probably 3 things. The two protagonists were brothers. Brother plaintiff was well into his 60s by the time the case got to be heard in the High Court. He was in his early 70s, if I remember correctly, by the time the case came to be heard in the Court of Appeal. The other brother was a bit older, but there wasn't much difference between them. The plaintiff brother had left home at 17, joined the priesthood, left the priesthood 10 or 11 years later. As I say, it was like a prototype. He was at some level kind of a favourite son of his father. He joined the priesthood. He was educated to 3rd level priesthood. He became a teacher. He left the priesthood. He married. He had children. But he had left his teaching to do something else which didn't quite work out. And he was of very modest means. He lived in the UK, and he was of very modest means. His wife had a part-time job as a nurse. His means were quite modest. And he still had quite a large mortgage in his early 60s. The other brother had left school early, gone to mind the family business, which was a pub in a good town. He had gone off to agricultural college after he left school. His parents persuaded him to leave the agricultural college and come home and mind a pub. There were 2 pubs at one stage. The pubs were highly successful. The brother plaintiff said, but we all worked in the pub. We all washed glasses, we all moved stuff around, we all worked in the pub since the time we were 8 or 9. So the fact that this brother came home and gave up his job to work in the pub, and the fact that this brother did all that work when he was a kid and eventually came to run the pub, really shouldn't necessarily give him any moral claim. The brother who was sued, the personal representative, was given the entire of the mother's interest in the pub, which at the time of death was worth 1.2, 1.3 million, and there were almost no debts in the pub. The brother who sued was given a share in the balance of the estate, which turned out to be slightly less than €100,000. It was around, he was going to get about 18,000, and of course the real difficulty with this case was that costs were going to come out of the residue, so nobody was going to get anything from the residue, and even the costs of administration were going to come out of the residue, so the residue really wasn't enough to meet anybody's claim. So Brother A, the plaintiff, sued. He said that the mother hadn't met her moral duty. The quirk in the case, which was really important point, and one I think that hasn't really ever been looked at before, was he argued a number of things, but one thing he argued was that his late father, interesting because there was a kind of an emphasis that the dad would have known what to do and the mother didn't quite, but that his late father had left the estate equally between everybody, and that the mother, he left it to the mother and in default to the children, and that the mother really was not a businesswoman and had stepped into his shoes and was obliged to at least consider his approach to moral duty in how she dealt with it. Now, she was dead, he was dead 20 years, but that didn't quite matter. The other interesting point about, and so we had to consider that, the High Court was somewhat persuaded by that argument, and the High Court was persuaded that there had been a failure of moral duty. Mostly, to be fair to say, because Judge Murphy took the view that by the way, it took something like 11 years for the case to come on for hearing. It was completely, again, that's another example of how we have changed, because this doesn't happen anymore. We heard this case and delivered our judgment within, 6, 8, 10 weeks or whatever. There's no delays in the system of the same kind that there were then. In any event, Judge Murphy took the view that there had been a failure of moral duty, and he gave the plaintiff's son more or less half of the estate. It was more or less half of the estate because he took account of various things that don't matter to the argument. And he did a number of things. He first of all forgot something very important, that in the course of the years when the mother and father and eldest son were running the pub, they had borrowed money, and for that purpose they had rejigged the enterprise, and they had established a limited liability company, and the mother had 25% of the limited liability company, the son had 25%, and the father had 50%. So the mother, when she died, only had her husband's share and her own share. She only had 75%, and the son, the surviving son, had 25%. Judge Murphy made a mistake in that, or we regarded that he made a mistake, in that he failed to have regard to the fact that there was probably no market for 75% of the shares in a limited liability company held in a private limited company with only 2 shareholders. There probably was no market. And that he absolutely, and this is really important I think, he absolutely forgot to have regard to the tax implications of A, selling the asset, B, selling the asset and taking the money out of the company, and then trying to distribute the asset thereafter. So he completely failed to do that, and the approach of the Court of Appeal was that you had to look at the reality of what the distribution would be post the award under Section 117. You had to look at the tax. And that's an interesting thing, because I think it's the first time it's found in the case law, the first time it's really found as a real pointer. And it is also found, you'll all know, in family law and case law, where the courts have always said you must look at the real value post-realisation of assets, and you must take off capital gains tax, etc., and the costs of sale. So that was a really key part of it. But the really important point about this case was twofold. One, the age of the brothers. And there's a tone running through the case, and it's worth reading for this, that really at a certain point, people get on with their lives, they live independent lives. And to be coming back in your 60s or late 50s to claim a share in an estate, when you've been gone from the management of the property for all your adult life, and you've taken independent choices, that word is used in the judgment, you've taken independent choices as to how you live, that moral duty has to be looked at through that prism. But so that's a very important part of the case, and I think it will have an influence in how the lower courts look at 117 claims now, because there has been a tendency to kind of blinker and say, right, at the date of death, what was the state of finance of the various siblings, and to do some kind of a division in that way. And this is a slightly different approach. Whether it's a very different approach or not, I don't want to say, but it's a slightly different approach, and it's an approach, I think, that's consistent with the policy behind the legislation, and also with our modern knowledge and thinking regarding tax. Tax is a very big part of the distribution of assets. But the real point in the case that I think you should read is this. The focus in most Section 117 claims has been on the failure of moral duty to the plaintiff. In this case, the judgment of this court looked at the moral duty that was owed to the person who inherited the pub. And the court held that that moral duty was an overriding or overarching duty which was not displaced by any duty to the other children, to the siblings. Because he had given up his life, he had given up his career, he had stayed at home, and he had been promised the pub over the years. So it was an alternative approach to that very vexed question of promissory and proprietary estoppel, particularly promissory estoppel, which always has played a big role in these kinds of cases. So it's another approach, and I think an approach that probably that favours this this line of thinking, that where are the moral duties and where are they to be balanced, and is there one that overrides the others? And I think this is the first case where the question of the overriding moral duty to the person who inherits defeated all other moral duties. And I think it's a very important case for that. It's also a case, I reckon, if you spoke to the man in the street about it, would say, that's the right answer, for heaven's sake. What were you doing, forcing a man in his early 70s to sell a pub, which was certainly not worth 1.2 million now, to sell a pub which one of his children had moved into, to basically get only half of the asset that he had built up with his parents, when he was the only one of the family who hadn't got their level education, and the only one of them who had stayed at home to mind the family, mind the parents, mind the pub. It would be very easy to move that thinking to farms, very, very easy. Very easy to move it to any kind of family business, and I think it's a very important decision. And I think it's, even though I was on the court, maybe I shouldn't say this, I think it's a very modern decision. I think it really looks at what the real impact of 117 claims would be, and what the real thinking about very adult children. I mean, these men were in the court. They were very elderly men, because they were in their late 50s when their mother died, which was almost 20 years ago. So yeah, they were very elderly men. I shouldn't say that now because I'm beginning to get there myself, but you know, they were men of a certain age. And there was something almost shocking about seeing two brothers having that fight when they were that age, when in fact they wanted to be retired. They didn't want to have that fight. And when the effect of the 117 order that had been made in the High Court would have been to entirely dismantle family business, because it would have to have been sold. Nobody would have got enough money to do much. In fact, the evidence was that if the 350,000 that Judge Murphy said should be given to the plaintiff brother was paid, there wouldn't have been 350 left for the other brother. And so it was a too blunt an answer. So I think we should look at it. Apart from that, I hope you have a very nice day. I'm not able to be here. I came from Cork. I come from Cork, probably, and I'm exercising my franchise in Cork because it's the last bastion. I can't quite feel that I've left Cork, so I still vote there. So I'm off to do that now. Have a good day. The papers are very good, very, very good. There's an interesting discussion around the statute of limitations, which I think is a big point out there at the moment. I think there's a lot of new thinking. There's a very good recent judgment of McKechnie's in the Supreme Court called Brandley and Dean, for those of you who haven't read it, on the running of time in building claims. Very important judgment, very positive judgment for plaintiffs. Follows the old law, but a very positive, intelligent look at the law. And there's been a certain number of cases on the running of time in banking cases, which I think are also important. So have a good day. I will definitely see you at the Congress, and I'll probably have to, I'm the only Irish judge member, so I think I have to take a big role in it. So have a good day. Thank you very much.
Our next speaker is Paraic Madigan. Paraic is head of client in Massachusetts. Paraic is going to speak about anti-money laundering legislation, which I'm sure is a topic that Paraic will make his own and very interesting. The slides aren't actually in the pack, but we probably will make those available at a later stage. Paraic is head of private client. He advises on personal estate and tax planning, wills, trusts and international estates. He's also an associate of the Irish Taxation Institute. He is a member of the Public Policy Committee in STEP, and he is also on the Royal Society's AML task force. And we'll
relevant in 117 litigation. But that's actually worth the fee for being here alone. Certainly found it very, very useful. I am going to talk about anti-money laundering legislation and try and take you through some of the issues that are relevant to that.
On.
Okay, thank you. I'll do it with it. Okay, that's right. Anyway, as I was saying, Judge Baker was worth the cost of turning up the road. What she said, it was certainly very insightful, which is useful. Anti-money laundering legislation, and I'm struck that when I started in practice, I think everybody here is practicing in a sphere that's regulated in some way. This was not really a concept that was material. And what I'm going to try and do is take you through some of the thinking, I suppose, behind the approach that the EU takes in anti-money laundering legislation, which obviously forms part of Irish law, and some of the implications that it has for us practicing in the area of family wealth in the different way that we do that. And the first part of the slides, I'm not really going to follow through the detail of the paper, but that's available to those of you who want to follow up later. The first part of the slides I've actually taken from the commentary that precedes the fifth anti-money laundering directive, because I think it usefully encapsulates the objectives of the legislation, requiring that the identity of beneficial owners of assets be established, and the requirement that that information should be available in a manner which is transparent. And there's a strong legislative view that public access to information about beneficial ownership of assets is important, and that includes access by journalists or other commentators who have no connection with the owners of those assets. It is said to be important in terms of giving confidence to those who avail of and invest in markets, and that's something I think that we're all keenly aware of. There is a recognition, and I think we'll come back to this a little bit later in the talk, about the requirement for there to be a balance between the general public interest in the prevention of money laundering and the protection of rights of the holders of assets. And that's a balance that is moving on a continuous basis. And there is a strong view that the availability of public scrutiny will prevent the misuse of legal entities. Now, I sit in this public policy committee, and John Riches, who co-chairs it, says who would set up a trust for the purposes of trying to launder money. There are obviously a lot simpler ways to do it, apparently. And I don't really believe that structures of the nature that we advise families on are actually generally used for these purposes. The focus on information being available to members of the public in registers is recognised as having some limits, particularly if it exposes individuals to personal risk. And the concept of legitimate interest is one which is subject of an ongoing public debate, and I'll go back to this a little bit later in the paper, as to what constitutes legitimate interest in terms of an entitlement to accessing information about assets and who may own them. And the directive, as one would expect, says that it respects the Charter of Fundamental Rights of the EU. And again, that's another point that I'll come back to a little bit later, because it does deserve a little bit of comment. So, taking all these points on board, and where the information I've just quickly gone through, and it's included at much greater length in the paper, concerns the MLD 5 5th directive. The 6th directive is under active negotiation at the moment, and this is a moving thing, and it's developing very, very quickly. So I think it's useful to try and extract the principles which drive anti-money laundering legislation around the importance of identifying the beneficial owners of assets, legislating for offences in the area, and then the requirement for the exchange of information between different jurisdictions, so that member states of the EU and indeed wider jurisdictions have access to relevant information concerning the assets which individuals resident in their jurisdictions hold. So I'm going to start by looking at some relevant offences which have been established by statute in Ireland. And the key here is obviously the Criminal Justice Act of 2010, which criminalises the handling of the proceeds of criminal conduct and constitutes a range of offences where any person is holding property derived from or obtained through criminal conduct, direct or indirect, in whole or in part. I will come on in a few minutes to talk about the fact that tax evasion is a criminal offence in this jurisdiction where it is the TCA, and that tends to be the area where I suppose get exposure to these issues in practice in circumstances where persons may be holding assets which have not borne their fair amount of tax, and inevitably it is going to be necessary to say to such a person, the monies that you are concerned about do constitute the proceeds of crime, because there has been a breach of tax legislation, and clearly it is important that that breach of tax legislation should be remedied by making an appropriate disclosure and dealing with the requirement to pay the relevant tax. Section 16 of the Criminal Justice Act of 2010 makes it clear that breach of tax law, whether it's an offence in Ireland or outside the state, constitutes an anti-money laundering offence. Section 107.8 of TCA is the provision in the Taxes Act which constitutes the evasion of tax as an offence, and states that any person who is knowingly concerned about the fraudulent evasion of tax is guilty of an offence. And indeed, any person who is knowingly concerned or reckless as to their role is also exposed. Now, this is not, I think, going to be particularly newsworthy for anybody in this audience. We're all familiar with these responsibilities and the offences that arise where there has been a breach of the tax legislation. I do want to just spend a few minutes talking about the issue of advisors and the implications for advisors. And this particularly came up in the context of some litigation concerning NIB, which is quite dated at this stage. But it concerns the implications where advisors may be in a position of assisting clients making disclosures, and the possibility that some of the information which is provided to a tax official in the course of dealing with those issues may form a basis for revenue to initiate a criminal prosecution, and the potential implications not only for the person who's charged but also for the advisor who has provided relevant information. And arising from the NIB case, the general law, as I understand it, is that if information is provided voluntarily, then it may be used in subsequent proceedings. But if information is provided by way of a statutory obligation, then the information may not be used in subsequent criminal proceedings. So it's an important factor to be aware of when disclosures may be made to the tax authorities concerning monies which are in breach of tax legislation. The Institute of Tax has, I think, given a useful warning, caution, I guess, to advisors as to the implications of their actions and statements in dealing with circumstances of this nature. And really it's just a word of caution in dealing with these issues. It's particularly relevant now because for over 2 years it is not possible to make a qualifying disclosure in circumstances where a breach of tax concerns monies held offshore. So a qualifying disclosure cannot any longer be made, and the rules that we would normally be relying on are said not to apply. So where is this relevant? And we sometimes see this as a regulatory burden. And I just want to mention a couple of examples where breaches of anti-money laundering legislation have got some publicity recently. And the first one concerns Danske Bank. And I think this is a bit of a smorgasbord. It's a sandwich that's gone badly wrong, and does carry a little bit of a smell from the perspective of Danske. The material on this slide is based on a report from Reuters referring to the arrest of employees, the money passing through a certain branch of the bank, which was said not to be compliant with anti-money laundering rules. And I think, as those of you who've been following this in the media will have seen, there has been a significant loss in value for the bank. and significant reputational issues, which it is now dealing with. Certainly, a recent talk that I attended on anti-money laundering, where a speaker from the central bank was participating in the panel. When asked, what would give rise to a real concern from the bank's perspective, he did cite this recent publicity as something that would be of very serious concern to the authorities if it was to be found to occur in Ireland. The second example, just bringing it back closer to home, again concerns a recent activity by the central bank in its capacity as regulator of a stockbroking firm. There was a significant fine for, in essence, as I understand it from the ruling that the central bank handed down, there was a failure to institute a regime of carrying out appropriate money laundering checks, of having procedures in place within the business, and ensuring that staff were appropriately skilled in dealing with the regime, and looking at the people around the room. Many are regulated by the central bank, others are regulated by the Law Society, others are regulated by the Proper Council, but ours are don't hold cash, so they get an easier run, I think, on this one. But these are issues that certainly regulatory bodies are quite keenly concerned about, and are generally focused on the implications of these issues. The Gardaí, and I guess every time there's a raid by Gardaí, or there's goods seized, invariably there's reference to individuals being charged with anti-money laundering offences. This is quite prevalent. It's a bit like when you hear in the US about law enforcement raids on individuals involved in organised crime, and mail fraud always comes up as one of the things that people were charged with, because they were using the public system to move money around the place. And I think breach of anti-money laundering legislation has now become an equivalent issue in the modern world in which we live. The money mule issue is an interesting one. Not quite sure how that plays out, but it's got quite a lot of publicity recently. So, having looked at the objectives of the legislation and the offences on the books in Ireland, how are the principles of anti-money laundering legislation enforced? And it's generally enforced, certainly insofar as the tax legislation is concerned, by exchange of information between different jurisdictions, whether it's double tax agreements, information exchange agreements, and then FATCA, which was introduced by the US, which essentially involved the US deciding in 2010 that regulated businesses or providers of trust services or company services around the world would be required to report annually as to whether and to what extent there are US persons benefiting from accounts or trusts or other structures. That was, I guess, followed up by the OECD, which decided that, well, that looked like a very good idea. The OECD has had a much bigger reach, because over 100 countries have now signed up to the Common Reporting Standard. Its objectives are similar in form to those of FATCA. It's to enhance the mutual exchange of information and establish a common standard for participating jurisdictions. Interestingly, the US has decided not to participate in CRS. So having had this good idea and sorting it out through FATCA, they've sat in the background as the OECD decided, well, this is something that we should bring to the rest of the world, which is an interesting approach from the perspective of the US. I'll say no more about that. So, bringing this back to closer to home, how is this relevant for families who advise, and what is its relevance? When I was referring to the 5th directive earlier, I was talking about the requirement for information concerning beneficial ownership of assets to be available in public broadly. So I'm going to look first at the regulations concerning Irish companies, because they have proceeded more quickly than those in relation to trusts. So, it has been a requirement under secondary legislation for beneficial ownership of Irish companies to have been established a number of years ago. Matters now moved ahead earlier this year with the requirement for a central register to be established in relation to Irish companies, and this will become effective on the 22nd of June this year. And what this requires is that the information concerning the beneficial owner of a company must be held by the company, must be available in what's going to be a